Good morning, dear participant, panelists, and guests. My name is Oksana Pokalchuk, and I'm honored. It's a big honor for me to moderate such an important and timely panel, Crimea and the Great War, how to ensure the responsibility of the Russian Federation for international crimes. And first, I want to introduce our speakers to the audience. Ms. Vesna Škare-Ožbolt, Commissioner for the President of the Republic of Croatia for the peaceful reintegration of the Danube region from 1995 to 1997, Minister of Justice of Croatia from 2003 to 2006. Mr. Ihor Zhovkva, Deputy Head of the Office of the President of Ukraine. Mr. Anton Korynevych, he is joining us online, Ambassador at Large of the Ministry for Foreign Affairs of Ukraine. Mr. Dmytro Koval, lecturer at the National University of Kyiv-Mohyla Academy, legal director of NGO Truth Hounds, member of the Crimea Platform Expert Network. And Ms. Kateryna Busol, Ukrainian lawyer and a senior lecturer at the National University of Kyiv-Mohyla Academy, Ukraine. In the 20th century, humankind took an enormous step to put an end to wars and the horrible crimes connected with violence of one group of people against another. In fact, the establishment of the UN and countless political and legal mechanisms, both local and international, were supposed to work on prevention of such crimes. However, and history has shown, unfortunately, that the existing mechanisms and practices are not sufficient for prevention. Russia started its atrocious, terrifying war against Ukraine with the occupation of Crimea, and since then, as we see, its actions in this war have increasingly, blatantly violated norms and principles of international law. Meanwhile, Russia continues to hope for impunity for the atrocities it committed. We know that impunity gives rise to ever new crime. That is why today we are going to speak about ways to bring Russia to justice for the committed crimes and the difficulties we face on the way to restoring justice. Only full and uncompromising termination of impunity for crimes committed may set the process restoring the balance of justice for victims and survivors into motion. Given that the field of crimes is truly enormous, we have to focus on a part of them during today's discussion. That is why today we are going to speak about Russia's responsibility for international crimes. The concept of international crimes is not defined by a universal accepted formulation, but there are four categories of international crimes: genocide, crimes against humanity, war crimes, and crime of aggression. And I suggest our discussion be divided into two parts. During the first part, it will be dedicated to the crime of aggression, and the second will be dedicated to other international crimes. And every panelist will have 5 minutes to answer the question. So, my first question would address to Mr. Ihor Zhovkva. Dear Mr. Ihor Zhovkva, could you please tell us about what is currently happening in Crimea and in other Ukrainian territories occupied by Russia, as well as about the development that led up to it? How does the Ukrainian government see the solution to the situation now?
Thank you. First of all, thank you for the organizers for having this very important event ahead of the parliamentary Crimea Platform Summit. Again, the initiative of President, which started last year with the Crimea Platform First Summit, today is spreading on several dimensions, parliamentary dimension and expert dimension today are very important. In order to answer your question, we probably should definitely start in 2014. Then let's be very honest and blunt. The world community, the international community, just overslept the attempted illegal annexation of the Crimea by Russian Federation. Everyone was silent, or even more than silent, saying that, or even not saying that something is going on. And that's what happened, and that's where those so-called illegal referendum started, and then those decisions of the Russian parliament and the Russian leader, and that's when it spread to other territories, and that's when it spread into the open war in 2022. Had the world been more reactive in 2014 and the world has started to awaken only after the situation with the MH17. Before that, sorry to my European colleagues and partners, you were silent. The same model is applying today by Russian Federation in the other occupied areas. It looks like they don't know how to invent something new. They take the same scales, they take the same standards, they take the same patterns, and they do again the same referenda. Then they have the decision of Putin, then they have the decision of the parliament, then they have change of constitution, similar approach. But luckily this time the world community, the international community is not silent. What is going on in Crimea now? We didn't know much after 2014. That's why when my president initiated this initiative Crimean platform, the task of this platform was twofold. Certainly the task number one is the deoccupation of Crimea by all possible means. And I here put a full stop, we all understand what we are talking about. But second task, which is immediate, is the human rights protection in the Crimea, current Crimea. When before the open war, we were telling to international community, we don't know, you don't know what is happening in the Crimea. You don't know how many people arrested. You don't know how many people deported. Yes, we understood the numbers more or less. But what is going on in terms of military concentration in the Crimea? We asked the international community to pay attention. You remember that starting in 2014, we are voting 2 resolutions each and every year in the United Nations General Assembly. Resolution number 1 being about militarization of the Crimea, and resolution number 2 being the human rights protection in the Crimea. We turned to the International Court of Justice on 2 main conventions. The first being the financing of terrorism, and the second being, again, about human rights. And what did we have from the international community? Yes, the ICG procedure is very complicated and it takes a long time, though we're having first successes there. I would just remind you that the first immediate rulings of the International Court of Justice was to immediately react for Russia in the occupied Crimea, to get the access to the Ukrainian language in the schools and in the media, to renew the Majlis activity. Nothing in the close happened. And again, no one reacted. So that's why my president decided to have this initiative of Crimean platform with these 2 most important things. Now, unfortunately, the situation even worsening, and we see that the all new ideas which Putin invents about mobilization, for instance, or additional mobilization, it again starts with the Crimea. It starts with the Crimea, and then it spreads to the temporarily occupied territories of Ukraine. It spreads to Kherson, it spreads to Zaporizhia, and to the Donbas. And yes, we can say that Crimea became a polygon for Russian Federation to test the new aggressive actions. We warned the international community before 2022 that, look, something military-wise happened in the Crimea. You do not pay attention to this. It is turning slowly from the international resort to international nuclear or military testing ground, and that's what happened because the invasion to the Kherson region started from the Crimea, and we all knew that, and we asked the international community to pay attention for this. And unfortunately now, everything bad which is going on in the territory of Russia, they also tested, or they first tested in the territory of Crimea. Unfortunately, no big change as far as the protection of human rights. I talked already about the Ukrainian language in the schools and the media, whatever. Unfortunately, nothing good about the inserting the people from other parts of Russia to the Crimea and deporting the indigenous people. And that's why my president adopted a law on indigenous people last year, and this year we have to implement it on the level of cabinet of ministers, and we are doing this. Tamila Tasheva knows how important is the activities of the government, coordinated with activities of the parliament, and presidents paying attention to this. So, unfortunately, if the international community would not play that same unanimous response what we need in 2014, the actions of Russians will be further on because they only feel force. When today or tomorrow in Croatia, more than 40 speakers are getting together to discuss, for instance, how to adopt unanimous resolution on calling the Russian Federation a terrorist state. That's important, and that's what is heard in Russia. When all the speakers will commit themselves to adopt the resolutions in their respective national parliaments for establishment an ad hoc tribunal, what we will be talking today about, is also their task, and it's also what is heard in the Russian Federation. We will later talk about what the president is doing, but you definitely know that he was raising the subject with each and every leader. So thank you for this very important initiative to unite the expert community. We really need the expert advice. We really need the actions how to do when the Crimea will be deoccupied. But before that, we have to think what will be economic-like model of development of the Crimea, what will be the judicial model, what will be the situation with the environment. We have to think now. So you know that our experts, our Crimean platform office is already doing very important thing in preparing those first steps after the occupation, preparing the economic model. So we all have to think and act together. Thank you.
Thank you very much. Can you hear me? Yeah? All good. Thank you very much, Mr. Ihor Zhovkva. And I want to pass it over to Mr. Anton Korynevych. Do you hear us? The connection is fine. Can you hear us, Mr. Anton?
Yeah. Good afternoon from Kyiv, dear colleagues.
Hello, hello. Dear Mr. Anton Korynevych, we can hardly imagine how challenging it is to be working out the political and legal framework for the creation of a special tribunal, what now Mr. Ihor Zhovkva has told us about. May I ask you to outline or to share your vision on how this tribunal could be set up?
Thank you for your question, Ms. Pokalchuk. And first of all, of course, I would like to mention that it is a big pleasure and honor to be talking today within the first parliamentary summit of the Crimea platform of these discussion panels, together with such respected and authoritative speakers. And of course, for myself, it's a great endeavor that our common efforts and of course the initiative of the President of Crimea platform is getting such a big support and is moving further in different dimensions, in particular within the parliamentary dimension. It's truly wonderful, and I'm sure that all these efforts are really struggling, and they will be finalized with the deoccupation of our Ukrainian Crimean Peninsula. And of course, we in Ukraine, and not only a lot of lawyers, a lot of politicians, international community, were struggling to find the right answers why the Russian Federation, and in particular the political and military leadership of the Russian Federation, were not brought to responsibility, to accountability for actually using of force, the illegal use of force, and committing aggression against Ukraine since 2014. And actually, this aggression of the Russian Federation started in late February 2014 with exactly the occupation, temporary occupation of the Autonomous Republic of Crimea and the city of Sevastopol. As of now, Ukraine effectively and vastly uses all the possible international legal mechanisms and instruments and tools to get Russia and its leadership responsible, but we do feel that there are gaps which are not filled, which we need to fill, and actually these gaps are about actually starting the aggression against Ukraine in late February 2014. And that is why, since this aggression started in 2014 and this crime of aggression is still continuing, we are sure that one of the relevant answers, and probably the principal, the main answer, is the establishment of the special tribunal for the crime of aggression against Ukraine. The establishment of this tribunal and its work and mandate jurisdiction will concern exactly the crime of aggression against Ukraine, which started from Crimea, and that will be the relevant legal response for the leadership of the Russian Federation for all the actions they have been committing and still commit since late February 2014. And of course, the establishment of the special tribunal for the crime of aggression against Ukraine is now one of the priorities for Ukrainian government, for the office of the president, for, I would say, all the stakeholders who are taking part in these efforts, in this initiative. And this idea has already summoned a good level of political support from, I would say, different stakeholders, Parliamentary Assembly of the Council of Europe, Parliamentary Assembly of NATO, OSCE, European Parliament, national parliaments of Ukraine, Lithuania, Estonia, and the Netherlands. So we see how parliamentary track and parliamentary element is important in all such endeavors. But of course, all in all, we do hope that all these efforts will bring us to the establishment of the special tribunal. It is quite understandable that this tribunal should be international in nature, meaning that it does need to include international elements, because first of all, this is the issue of legitimacy and credibility. Of course, it is well understood that we need support from international partners to establish this special tribunal, and on the other hand, this international element and legitimacy and credibility are really necessary for this tribunal to be able to act responsibly and in a right and correct manner. Because, of course, there will be some legal issues and challenges which we will need to overcome. In particular, the obvious elephant in the room is the issue of immunities, in particular the functional immunities of at least so-called Troika. Head of state, head of government, and Minister of Foreign Affairs of the aggressor state. So in order to get all the things done, we of course are now dealing with several options how the special tribunal may be established. The first option is so-called Nuremberg model, which is about establishing the special tribunal on the basis of multilateral treaty between states, so that it means that Ukraine and other states, governments of states, will sign and then ratify the treaty about the establishment of the special tribunal, and also the statute of the special tribunal, which will be an annex to the treaty. This special tribunal may be also established on the basis of agreement of Ukraine with international organization. This may be a global international organization, meaning the United Nations, with having this issue also discussed on the level of General Assembly and with the adoption of the relevant United Nations General Assembly resolution, or on the basis of agreement of Ukraine and regional European organizations. Say this may be European Union or the Council of Europe, since really this aggression is the biggest war in Europe since 1945. And Europe, of course, is a continent of rule of law, of protection of human rights, and such acts of aggression and the relevant crime of aggression, which are now being committed by the Russian political and military leadership, cannot be ignored and left without response, in particular in Europe. So with saying this, we see that we can go either through the multilateral treaty between states or through the agreement of Ukraine and international organization. As of now, Ukraine has already prepared all the needed relevant drafts of agreement, treaty itself, and the statute. We have disseminated it throughout our international partners. These drafts are written in such a way that whenever option is chosen, we may then proceed with working on it, and the other things might be left out of these agreements. So to finalize, the big idea, I think, that is now being crystallized in the international community is that there must be responsibility for the crime of aggression against Ukraine. This aggression cannot be left without response. And thus, the only question is to how, which is the best option to establish a special tribunal, and I'm sure that together with our international partners, we will get this task done.
Thank you very much, Mr. Anton Korynevych, for sharing your vision on how this tribunal could be set up. And my question would go to Ms. Kateryna Busol. Ms. Kateryna Busol, what are legal challenges in terms of the three approaches that were mentioned by Mr. Anton Korynevych?
Thank you very much, Oksana, and thank you so much to the organizers for hosting us. However beautiful the city is, I really hope that we'll soon have the next meetings related to the Crimea platform in peaceful Kyiv and in peaceful Ukrainian Crimea. And in my presentation, I will address three challenges related or raised by international lawyers who inevitably advise their policymakers across the world with respect to the support of the creation of such tribunal. The first concern is the temporal concern. It's very obvious to Ukrainians and Ukraine's international partners, but not everyone around the world, that the tribunal should indeed look at all actions of the Russian Federation on the territory of Ukraine since 2014. Unfortunately, for many colleagues, including international lawyers, my own colleagues, it seems that the Russian aggression started in February 2022, but from the standpoint of international law, as well as, of course, from the standpoint of the Ukrainian government, and Minister Kuleba was very precise on that during the accountability conference held in The Hague this summer, that the tribunal should look into Russia's aggression not since February this year, but indeed since the occupation of Crimea in 2014. The second concern is the legitimacy concern. What mode of the establishment of the tribunal would make it legitimate under international law and would make it valid for the future generations? And indeed, all the three options that Mr. Korynevych has mentioned are favorable for Ukraine, but there has been a concern that, for instance, establishing a tribunal under an international treaty with just a couple of states, or just within the framework of the Council of Europe or the EU, might make it kind of original tribunal. So of course the biggest aspiration would still be to get the support of the United Nations, to get the support of the UN General Assembly, to really validate the international relevance of this tribunal, to make sure that it's not just the case between Ukraine, Russia, and not just the case for Europe. And we have seen the unparalleled support of the international community in voting for the first General Assembly resolution after the full-scale aggression in March this year. And I think it's quite promising that the Ukrainian government has really enhanced its outreach to the countries of the global south, of South America, of Africa and Southeast Asia, to really explain all the particularities of this aggression, as well as why its prosecution should have the international foundation and desirably be backed by the UN. The third concern is the selectivity concern, essentially whether the prosecution of Russia's aggression against Ukraine would constitute selective justice, would constitute the accountability for this particular case of aggression, but not for other previous instances of the use of force. And I think Ukraine should be really strategic in playing with this argument by saying that on the one hand, it indeed this tribunal would address a particular case of aggression, which is really horrendous since the World War II and since the Yugoslav wars on the European continent. But on the other hand, this prosecution could be and should be a catalyst for the reform first of the International Criminal Court's approach to prosecuting aggression, because it's too limited, and Ukraine should be an example of this limited nature of the current international judicial framework in reacting to aggression and in reforming its response. And second, that should also be a push for the wider reform of the United Nations. And as an international lawyer, I can say that this debate has never been as lively as it is now. So these are the arguments about the catalytic pushing nature of the potential aggression tribunal. And finally, very briefly, and very importantly, the victims' consideration for the tribunal. Aggression is considered to be a crime against the state, but in fact, it is the crime against the people. It is the crime against every particular individual. So it's very important, and I have no doubt that Mr. Anton Korynevych and his team are looking into how the particular survivors, the particular individuals, will have their voice before this tribunal first, and second, how the judgment of the tribunal can and should impact the allocation of individual reparations to survivors and the wider reparations for the reconstruction of Ukraine. Thank you.
Thank you very much, Ms. Kateryna Busol. I'm very grateful for your answer. And my next question will be addressed to Ms. Vesna Škare-Ožbolt. Ms. Vesna Škare-Ožbolt, in your opinion, in in what way could Croatian experience be useful for Ukraine in its way to the creation of this international tribunal regarding the crime of aggression?
Well, our experience can help you a lot, because I will just show you our steps, how we, Security Council founded International Tribunal for former Yugoslavia. When in the process of dissolution of former Yugoslavia, Serbia and Montenegro attacked Croatia, supported by the Yugoslav army. The result was 1/3 of the country completely destroyed, thousands of killed people, 500,000 people were expelled from the houses and from the home, and atrocities, rapes, detention camps happen in our in these areas. United Nations reported very often about the situation in Croatia and in all the area of former Yugoslavia, also in Bosnia and Herzegovina. And later they founded a commission of experts who were reporting from the ground what was going on. This commission of the experts helped to create the tribunal. So in '93, Security Council resolution was, I think, 827, and we had the International Criminal Tribunal for former Yugoslavia. It was the first criminal court that UN founded, and it was the first international criminal court after the Nuremberg and Tokyo tribunal. But this resolution had, they create the statute, they create the protocol of the jurisdiction, they create the structure of the courts. So from '93, they actually started to work 3 or 4 years later, because they had political struggle, who will be the prosecutor, who will be the judges, how they will collect the money for the court. So if you ask some Croats in eastern part of Croatia, where atrocities happened, for example, in Vukovar, they will say this was the court with the smell of politics. So be careful, be careful. Not allow politics, world politics, to intervene in justice. What was the target of the International Court for former Yugoslavia? Target was to bring persons who committed serious crimes to the justice. Target was to satisfy the victims. Target was to create the peace and atmosphere of reconciliation. It was a pretty big mandate for the court. I must say that they fulfill only the first stage, that was bringing persons to the justice who committed serious crimes. Again, if you ask people in Vukovar, where 200 wounded people in the hospital were slaughtered, where we have mass graves, where are still 1,000 missing persons, more than 1,000 missing persons, still after 30 years, they will say that the international court was tiger without tooth. During the war, I was reconciliating this part of the land by peace, and I was the National Reconciliation President. And I can witness that without justice, you cannot have honest reconciliation. That's my message. Thank you.
Thank you very much, Ms. Vesna Škare-Ožbolt. That's really important to know. And I would like to pass it over to Mr. Dmytro Koval. Dear Mr. Dmytro Koval, in your opinion, and based on all the points and ideas shared by our speakers, could you please sum it up and say why do we need a special tribunal for the crime of aggression?
Thank you, Mrs. Pokalchuk. I would probably compartmentalize the rationale for the creation of this tribunal on aggression into two baskets. We can call them jurisdictional basket and a substantive one. So I will start with the jurisdictional. The International Criminal Court, the usual suspect for investigation and prosecuting of war crimes, can't really get into investigation of the crime of aggression. That is because of the specific jurisdictional limitation enshrined into the Kampala Amendment that basically introduced the crime of aggression to the Rome Statute. So right now, the International Criminal Court can't investigate nationals of states that are not parties to the Rome Statute and that those states that hasn't ratified the Kampala Amendments. On the other side, the national courts and the national prosecutors will also have troubles with prosecuting of those who are responsible for the crime of aggression. First of all, crime of aggression is a leadership crime. Whatever definition of leadership we apply, be it a Nuremberg definition of leadership or the Rome Statute definition of leadership, anyway, the national authorities will face this dilemma of functional immunity that Mr. Anton Korynevych has already touched upon. So there is a thin agreement, I would say, that functional immunity can be overcome by when it comes to the international crimes. And this agreement we can see, for instance, in the International Law Commission of the United Nations draft articles on state officials' responsibility against foreign criminal jurisdiction. But even those articles, they do not reflect on the crime of aggression. So there is no really any agreement between the states that we can just ignore functional immunity when it comes to the crime of aggression. And that leads, of course, to the consequence that most of those who are responsible for the crime of aggression cannot be prosecuted neither by the International Criminal Court nor by domestic courts. So that's a jurisdictional side of the story. And now I will switch to the substantial one. It goes without saying that crimes should be named, or if such a crime is committed, it should be prosecuted, or the persons involved in its commission should be prosecuted exactly for that crime, not for the similar crimes, not for the crimes that is much easier to investigate or prosecute either internationally or domestically, but basically for those crimes. That is very important for the truth-telling. That is important for the creation of the historic narratives. That is important from the perspective of victims who suffered from the crime. That is important also to learn the lessons from the war, because without learning the lesson, there is no point of even speaking about the responsibility. I have to say that Nuremberg Tribunal, for instance, was very much aware of this fact. That is why, both in the judgments, and we can see this in the memoirs of those involved in the Nuremberg Tribunal, prosecutors and judges, they paid so much attention to the crime of aggression, crime against peace, as it was called then. That crime was basically framed as an enabling crime, the crime that gave the path, created the path for all other crimes to be committed. And that's exactly the case with Ukraine. The aggression against Crimea, aggression against eastern regions of Ukraine, and now the aggression of the February that started on February 24th is the enabling crime of the top officials of the Russian Federation that led to the commission of all other crimes. That is why, from the both jurisdictional point of view and substantive point of view, it's so important to have this tribunal.
Thank you very much, Mr. Dmytro Koval, for summarizing the need for the special tribunal. And now I want to switch to the second part of our discussion, namely genocide, crimes against humanity, and war crimes. And my first question would go to Mr. Anton Korynevych. Mr. Anton Korynevych, Yeah, I can see you. You can hear us great. What activities are being undertaken by the Ukrainian government to investigate these 3 categories of international crimes?
Well, thank you for your question, Ms. Pokalchuk. And really, I would like to stress and mention that now Ukrainian government and Ukrainian law enforcement agencies do have one voice policy in relation to accountability and responsibility for these mass atrocity crimes, these 3 categories of international crimes committed in the territory of Ukraine. Our Office of the Prosecutor General does provide, I would say, really serious and important job in relation to investigation and prosecution of alleged war crimes and crime of genocide committed in the territory of Ukraine. There are specific units inside the Prosecutor's General Office, in particular the so-called War Crimes Department, which is the leading institution in relation to everything which deals with investigation and prosecution of the war-related crimes, in particular war crimes and the crime of genocide. A lot of our international partners do assist our Prosecutor General Office in those investigations and prosecutions. We may all see and hear how the investigations teams from different capitals do come here to Ukraine, to Bucha, to Irpin, to Izum, in order to analyze, in order to investigate on the ground and to get their information from the first hand in relation to that crimes. A lot of advisory groups were established together with our international partners, both on the level of Prosecutors General Office and inside international organizations, for instance, inside the UN, the Accountability, Friends of Accountability Group for Ukraine, which enlists really huge number of states. There is also an important work of a joint investigative team, which is established with participation of Ukraine, Estonia, Latvia, Slovakia, Poland, Lithuania, Romania, other states, and it is also important that Eurojust and the Office of the Prosecutor of the International Criminal Court, for the first time in its own history, is a member, is a party to this joint investigative team. There is also important work of the Office of the Prosecutor of the ICC in relation to its investigation of the situation in Ukraine. And it is really good that the preliminary examination is over, and finally there is a stage of investigation, which is of course another step towards justice and towards accountability. We all know the importance, and we may feel the importance of the investigation of the situation in Ukraine for the Office of the Prosecutor of the ICC. And of course, we are sure and we hope that rather soon, sooner than later, there will be some in particular indictments and arrest warrants for the alleged perpetrators of these mass atrocity crimes in Ukraine. Ukrainian parliament, as we are today talking about the parliamentary track in particular, also does an important job in relation to securing accountability. In particular, recently, there were several laws adopted by the Verkhovna Rada of Ukraine, which are adopted in order to ensure effectiveness and efficiency of the work of the Office of the Prosecutor of the ICC in relation to the situation in Ukraine. In particular, as a result of these laws, of adoption of these laws, there is now a specific chapter inside the Ukrainian Criminal Procedural Code, which is about cooperation with the ICC. So that means that really we do pay a lot of attention to cooperation with the International Criminal Court and the efficiency of investigation of the ICC of the situation in Ukraine. I'm, of course, not myself a member of the Prosecutor's General Office, but I know from my colleagues who work there that the contacts with the ICC are really provided on the daily basis, and that this is an important work and important track. And really, we do hope that having this very serious response, both from the side of Ukrainian law enforcement agencies, in particular the Prosecutor's General Office, and from the side of the International Criminal Court, of course, will bring the results. And the results, of course, are about accountability and responsibility of those persons who allegedly committed war crimes, crimes against humanity, and the crime of genocide in the territory of Ukraine. I would like also maybe to stress important notion that, as you know, there is an interstate dispute application of Ukraine in the International Court of Justice concerning allegations of genocide case, which were filed in the end of February this year. In particular, on the 26th of February, And it was also like the response from the Ukrainian government in relation to that false allegations of genocide, that manipulation and speculation with the notion of genocide, with the very concept of genocide by the Russian political leadership, in particular, saying that some alleged mythical genocide committed in the territories of Ukraine, in particular in Donbass, led to the use of force by the Russian Federation against Ukraine. In that case, in the International Court of Justice, we will do our best with it, together with our international partners. And as of now, we have already around 25 interventions to this case from foreign governments to find Russian Federation responsible for misinterpretation, misuse, speculation, and manipulation with a sacred concept of genocide.
Thank you very much, Mr. Anton Korynevych. And now I want to pose a question to Mr. Dmytro Koval. Mr. Anton Korynevych just spoke a little bit about the genocide, and we know that the term of genocide quite often hits the news headlines. And I have a question. Would it be correct to apply the term of genocide to the situation in Ukraine now? And does the situation in Ukraine stand any chance of being recognized as a genocide by the world community?
Thank you, Ms. Pokalchuk, for such an important question. I would start answering with making the distinction between the political declarations on the crime of genocide and judicial proceedings. So on the side of these political declarations, their role, their function is very different from the one that judicial proceedings play. The function of political declarations is to attract international community's attention to the mass atrocities that may be characterized as a genocide. And as a result, to basically attempt to secure the proactive reaction of the states of the world to prevent the crime of genocide, that is unwrapping. So that's the reason why several states, 8 if I'm not mistaken for now, adopted the declaration saying that mass atrocities in Ukraine should be looked at from through the lens of genocide. And then there are also judicial proceedings. The level of scrutiny in juridical proceedings is very different from the one of political declarations, political statements. Here, the courts have to establish the link between those who perpetrated, aided, abetted, or incited the crime of genocide to basically the person who is responsible for those actions. The courts also have to establish that it was the genocidal intent that drove the action of that person. And that's, of course, an easy task. But with all the statements that we have heard already coming from top Russian politicians, statements that basically question the existence of Ukrainian nation, a question that say that that Ukrainians and Crimean Tatars kind of illegally occupy the territory that belongs to Russians, and all other statements of this like, we can say that there is genocidal intent, at least on the level of incitement, in the actions of top Russian officials. And then there are patterns of behavior of Russian soldiers on the Ukrainian soil. We see numerous killings, rapes, torture, deportations, organized systematically by the Russian state. That kind of advises us that those killings have something in common, that they have some greater goal, some greater aim, and that is to basically eliminate Ukrainian nation. There are also attacks on Ukrainian culture, both tangible and intangible. We heard about this already during the first session of this platform. And those attacks, again, witness to basically adds to the arguments of those international lawyers who say that what we are seeing now in Ukraine is genocide. So finalizing, I have to say that from my point of view, the arguments about genocide are plausible both on the political level, on the level of this declaration of the parliaments, and on the level of the potential juridical proceedings. Thanks.
Thank you very much for your vision. Thank you. And my it leads me to the next question to Ms. Kateryna Busol. Ms. Kateryna Busol, we often talk about the need to ensure individual responsibility for the crimes. But what about the responsibility for the media and religious leaders who may call for violence and engage in war propaganda? Are there any ways to ensure responsibility for inciting violence on the part of the media and religious leaders?
Thank you very much, Oksana, for this very pertinent question and very difficult from the legal perspective. The crime of incitement to genocide is a separate crime under the Rome Statute of the International Criminal Court. The criminal courts of various nations do also criminalize incitement to genocide or the wider incitement to war. And indeed, the international legal practice, especially from the Nuremberg Tribunal and from the International Criminal Tribunal for Rwanda, have shown us that the top media figures from the press, from the television, have been held accountable individually for inciting violence, including for inciting genocide. Now, how that happens in the court of law? The process of proving the incitement to violence and especially incitement to genocide faces the same standards and I would say the same hurdles as Dmytro has just outlined. First, in the case of genocide, a genocidal intent should be proven, an intent to eliminate in whole or in part one of the four groups. In the case of Ukraine, most likely that would be a national group. What potential does it have in the current circumstance? Both the Ukrainian human rights organizations and the Office of the Prosecutor of the International Criminal Court have preliminarily established the crime of persecution on political grounds for years, including with respect to Crimea. And it is up for lawyers now to build up on that evidence of the crime of political persecution and lead that evidence to the patterns of violence, of mass deportations, of rapes accompanied by genocidal rhetorics to prove a genocidal intent and its realization on the ground, on the one hand. And on the other hand, for proving the incitement, this essentially remote crime, either of a religious leader or of a media person, it is important to show two aspects of such incitement, that it was first direct, and second, that it was public, and then connecting it to violence on the ground could give the potential both to Ukrainian or foreign investigators and prosecutors to prove the incitement to genocide and other atrocities in their domestic courts, as well as to hopefully have these proceedings before the International Criminal Court. And what I would support in this case is that just the legal reasoning should be very, very cautious and carefully crafted and fact-based, but unfortunately it appears that the facts are piling up for actually being plausible to prove the incitement to genocide and to incitement to other forms of violence, including under the Rome Statute.
Thank you very much, Ms. Kateryna Busol. That's really interesting and important to know. And my next question will be to Ms. Vesna Škare-Ožbolt. Dear Ms. Vesna Škare-Ožbolt, we spoke a lot here about the international mechanisms and verdicts of international institutions, whatever it will be, tribunal or however we will call it. Could you please share with us whether Croatians, like people, were satisfied with the verdicts delivered by the international tribunals, in particular the Criminal Tribunal for the former Yugoslavia, or I don't know, International Court of Justice? So how these verdicts impact people, and how you were seeking to reach justice for survivors and victims on a national level?
That's a very good question. It depends. If you ask people in eastern part of Croatia, in Vukovar, where a lot of people were killed, and where the mass graves was founded, then they will say no, that was not the justice. That was not. We are not satisfied, and even now they are still asking for stronger penalty, for stronger punishment. Actually, as the International Tribunal finished its work, some cases are still opened, and very important cases. And we transfer, I mean, Hague Tribunal transfer some cases to the national courts. And in 2005, we actually educated judges, specialized them for judging the war crime. And we created in our country 4 investigation war crime centers to investigate. Even during the war, courts were judging, but in absentia, in absence. So all those who were judged in absentia, in absence, they could have opportunity to again have trial. So we still have on court's agenda the war crimes cases, still after 30 years. Thank you.
Thank you very much. Thank you for your answer. And I want to pass the last question to Mr. Ihor Zhovkva, if I may. Mr. Ihor Zhovkva, summing up everything mentioned above, could you tell us about what steps the Ukrainian government is taking to set up an international tribunal regarding the crime of aggression, as well as investigate other international crimes, and how could the international community support Ukraine and Ukrainian government in this effort?
Well, thank you. First of all, it was really a big intellectual challenge for me to listen today to the panelists and to Madam Vesna from Croatia. Yes, the experience of Croatia is very important for us, and that's why we are here. It's one of the reasons we're here as well. And the decision to have the Crimea platform in Croatia was very brilliant on behalf of your government. So it is really vital to have your experience now, bad and negative and positive experience, to be taken into account. For the time being, as we're still in war and we have to win this war, and we definitely win this war, we will follow all the possible ways of bringing all those responsible to punishment. Well, today we examined all the possible models. I will not dwell on it, but definitely the domestic courts, they will do what they can, and I hear the experience of Croatia. The ICC was mentioned several times today. Yes, we are having a wonderful cooperation with ICC as of now. Immediately after my president asked to turn to the ICC to start the investigations in the liberated areas of Kyiv region, Bucha, Borodyanka, Irpin, Kostomel, then there were other cities. Immediately Prosecutor Han came to Ukraine. He was several times already in Kyiv, meeting my president, meeting the Prosecutor General, working, as was today said by Mr. Korynevych, with the joint investigation team. And this is very important and timely, because you all who have the experience here know how it's important to have the timely and immediate collection of evidence, and we're really enjoying the support from the ICC team. And yes, we're enjoying the support from our individual countries. Immediately after the areas were liberated, several partners suggested to us the immediate help as far as their forensic experts concerned, criminal experts, and I can name you several countries. I think one of the first was France, then immediately Slovakia came, and now almost each and every member of the European Union are helping in this or that way. Someone gives us laboratories, someone gives us the experts, someone gives us financing, And that's where we are in collecting, fixing the evidence in order to place them in the due time to the court. So ICC is doing a very important job, and certainly we will count on the ICC to the extent where their area, their scope, where mandate is affording to us. And definitely International Tribunal ad hoc is the main important task now for all the institutions in Ukraine, starting from the president. We are really my president really raising this topic at every meeting or phone call or appeal with the international leaders in the international forum, starting from G7, proceeding with the United Nations, European Union, Council of Europe, and we see the immediate reaction. When my president was speaking in the Parliamentary Assembly of the Council of Europe, the resolution which was adopted after his speech had a very important procedure on the tribunal. And yes, the Council of Europe suggesting us to be the platform for the tribunal. I do agree with Kateryna that this approach might be limited, as well as the European Union, but we will now study and work in each and every direction. And something will work for us. International treaty is also, this model is also very important. We presented this international treaty to already more than 30 partners of ours. Ambassadors at Kyiv, foreign ambassadors do have on a permanent basis the information how it's going on. We will work with the United Nations General Assembly. On obvious reasons, Security Council is not the possibility, but the United Nations General Assembly, we are drafting the resolution, and hopefully in November, the resolution will receive the support. Obviously, it will not have 143 votes like we had during the last General Assembly resolution. Really, once again, many thanks for each and every country supporting this resolution. That was tremendous result, not only for Ukraine, but I think for the whole international community, when only 4 rogue states supported the position of Russia, and the rest of the civilized world supported the position of Ukraine, the position of a civilized world. So we will be working with the United Nations. We're already working with the countries of South. Kateryna was right that we secured the support of those countries. My president, for instance, had 16 phone conversations with 16 presidents of African continent, which is very important. And before that, unfortunately, I have to admit that Ukraine didn't pay much attention to this part of the world. Now, my president is correcting the mistakes. We are speaking to Latin American leaders, and definitely we are securing the support in our European and Euro-Atlantic community. So definitely we will win, and definitely we will succeed in bringing all those responsible to punishment. Thank you.
Thank you very much, Mr. Ihor Zhovkva, for summing it up and for formulating the calls for international community. And on this positive note, I want to express my sincere gratitude for the speakers of this panel and for sharing their meaningful and insightful input. I do hope that this discussion would lay the groundwork to restore justice for all those affected by the international crimes committed by Russia. And I hope that the result of this discussion will not be long in coming. And hope to see you soon in Bakhchisarai. Thank you.